When we're thinking about free expression, gay and lesbian people, I think one thing to focus on is publications and the media, particularly books. My name is Michael Bronski. I'm professor of the practice of activism in media at Harvard University. In the past 5 decades in England and America and maybe other European countries, there's been an enormous push against state censorship. Certainly in America, right, we saw enormous Supreme Court battles that allowed books such as William Burrough's Naked Lunch, John Cleland's erotic novel from the 1700s, Fanny Hill, Henry Miller's Tropic of Cancer were all seen as being they're not pornographic, but not obscene, which is the legal standard, right? Since then, right, it opened the floodgates to any number of highly literary to highly pornographic materials out in the culture. What's interesting is that there are 2 things here, right? One thing is that when we look at the history of gay and lesbian publishing, right, there's always been a different standard. In 1954, there's a group called Mattachine Society. They publish a journal called One, the Homosexual Magazine, which was confiscated by the post office, by the postal officials, in this 1954, because it had 2 stories that had, by our standards, they could be in Better Homes and Gardens or Red Book. They were not at all erotic, but they talked about gay men and lesbians. And that the post office decided that, in fact, homosexual content ipso facto was pornographic because it was simply gay and lesbian. One magazine fought this, and in 1958, so it took 4 years to get to the lower courts. In 1958, it went to the Supreme Court in a case called One versus Olson, in which the Supreme Court ruled that, in fact, homosexual material in and of itself was not pornographic. The Supreme Court at that point would have held that if, in fact, it was images of naked people having sex, that it would have been pornographic, right? But gay and lesbian content in and of itself was not pornographic. So, and since that time, and certainly by the later 60s, the market was flooded with heterosexual pornography, straight pornography, novels that discussed homosexual and heterosexual. By the later 60s, right, because of these Supreme Court rulings from the late 50s, early 60s, we had culturally people were publishing literary novels, pornographic pictures, all of which were protected under the First Amendment. One could argue, and I think it's true, that in fact, for the homosexual material, part of the key for that was this One Inc. versus Olson lawsuit from 1958 that said that any homosexual content by itself was not obscene, right? We all know that you can rent porno movies on TV now, you can get any number of books. Best-selling novels often have highly erotic and explicitly graphic content. It's all protected. So when we look at all these Supreme Court decisions, I'm thinking of the ones about Fanny Hill and Naked Lunch and things, right? Just before this comes this important decision, which is One Inc. v. Olson, based on the fact that one magazine called One, the Homosexual Magazine, was seized by the post office and was actually deemed as being pornographic simply because it had gay and lesbian content in it. The real importance, I think, of One Inc. v. Olson is that it really comes in the beginning of these other censorship things, and really sets the tone, saying that content per se, before you get to it being overly sexual or being too graphic, content per se should not be censored, right? And I think for gay and lesbian people, but I think for the entire censorship battle, that One Inc. v. Olson is this pivotal moment in which the Supreme Court says that discussing homosexuality in and of itself is fine. And what that meant was that on some level, right, that actually just the simple discussion made homosexuality okay because it was able to be discussed.